It's Entertainment Law Update, episode 169 for June of 2024. Getting ahead of myself here. Welcome to Entertainment Law Update from Los Angeles, California. I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
Well, thank you so much for being here, and thank you, Tamera, for being here. This is the podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and some analysis and try to have a good time while we do it. And this month will be no different, as we noticed right off for the start with my faux pas. It's almost July, but not quite. Anyway, Tamera, how are you? What's new?
You know what? I'm doing fantastic. Not too much new in my world, I guess. Yeah, it's hard to believe it's almost July. Next week, maybe a few extra days off for the July 4 holiday. So that's kind of it, you know.
Yeah,
we don't always want to talk about the weather, but hot.
It is hot. Yeah. Thank you. Things here on the West Coast in my neck of the woods are also hot. We had a big obnoxious wildfire last week that kind of had us on pins and needles, but that's seems to be past. And things are sort of quiet and I won't say relaxed, but quiet. So there we are. And we're excited to get back to the episode here. So this episode of Entertainment Law Update is sponsored by JD Supra, a leading platform in professional services content marketing, helping lawyers to turn their expertise into networking opportunities, media visibility, and new business. JD Supra publishes and distributes blog posts, articles, podcasts, videos, and other thought leadership to hundreds of thousands of subscribers each day, including business leaders, in-house counsel, media members, and the C-suite and others with a need-to-know interest in legal, regulatory, and compliance matters. JD Supra clients not only enjoy wide readership of their thought leadership material, they're also provided with the data and the tools to use, turning that visibility into marketing and business development success. You can get more information about JD Supra by visiting resources.jdsupra.com. And we're glad for them to be a sponsor.
Yeah, I love JD Supra, not only for us, but for using it, but also for our research and what other law firms' information they provide. So we're going to kick things off with a Supreme Court ruling, and I suspect next month we're going to cover more as we're realizing rulings are being handed down while we are recording today. But this one deals with the trademark Trump Too Small and whether or not it's allowed to be registered. And the Supreme Court says, no, it's not. So Vidal versus Elster, the Supreme Court struck down a lower court's ruling on a person's rights to hold a trademark on the phrase Trump Too Small, finding that the Lanham Act Names Clause does not violate the First Amendment. The Names Clause prohibits the registration of a mark that consists or comprises of a living person's identity. They're and without individuals' consent to that registration. So if you've ever filed an application for a trademark and it contains someone's name, you have to have an additional document signed for that to be registered. So Mr. Elster applied for the phrase Trump Too Small for T-shirts back in 2018, and it evolved from then President Trump making a statement regarding, prior to, this was in 2016, candidate Trump, during the Republican presidential nomination, different things, exchanges between him and Senator Marco Rubio. And I guess Elster, like many other individuals, thought it was a good idea to file a trademark application for that. The court looked at the issue really being, do free speech protections for criticism of a public figure outweigh the U.S. Patent and Trademark Office's concerns over a living person's right to ownership of their name? Elster's argued public figures, allowing public figures to trademark their own positive messages while precluding registration that criticizes them verges on viewpoint discrimination. And in a unanimous verdict, the Supreme Court ruled that the Lanham Act Names Clause, which prohibits the registration of mark that, again, consists of or comprises a name identifying a particular living individual without consent, does not violate the First Amendment. I was kind of surprised. This is the first time that SCOTUS has considered the constitutionality of a content-based versus content-based but viewpoint neutral trademark registration claim. And the majority writer was Justice Thomas. He took a historical approach looking at trademark rulings in the past and the deep-rooted Lanham Act's deep roots in our legal tradition, and recognizing that trademarks containing names have been restricted. And these name restrictions serve an established purpose and principle, and conclude that the Names Clause, while content-based but viewpoint neutral, is compatible with the First Amendment. And that's it. He says we need to look no further. The court explained that while common law has allowed for a person to obtain a trademark containing their own name, not to the exclusion of another person. I don't know if you've ever had a case like that, but I have. We see no evidence that the common law afforded a protection to a person seeking a trademark of another living person's name. So that there was no discrimination and that it doesn't discriminate based on viewpoint, violating the First Amendment. It's still content-based because it implements a ban based on the content of the trademark. So if you don't have consent, you cannot register the person's name in the trademark. There was a split in the reasoning, even though it was a unanimous decision. And the court, however, carefully to note that its decision is narrow in basis. We do not set forth a comprehensive framework for judging whether all content-based but viewpoint neutral trademark restriction are constitutional, the court said. So I decided to go look up and see how many Trump trademark applications there are out there. I also did this under Biden. Any guesses?
It's
for how many?
The hundreds or maybe even thousands.
Yeah, so I tried to narrow down and remove any Trump filings and Biden filings that look to be legitimate.
You mean from
controlled
them?
From them, controlled by them. I came up with over 350 dead applications that included the word Trump.
Interesting.
And 58 pending that look to be filed by third parties without authorization. On the Biden camp, there were 49 that looked to be dead that were not affiliated with him, and 8 pending. My favorite, though, was Trump Tan. And the argument was this is part of his name, image, and likeness because it's well associated with him as to his skin tone is a known characteristic. You know, if we've got to talk about the Supreme Court, I just thought we should talk about self-tanning as well. So
this is interesting to me because Trump is a word in the lexicon aside from his name.
That's
it
right.
is a term used in bridge, the trump card, and trumping something to mean superseding or overruling. And my last name, Firemark, is another such. I happen to be one of the very few handful of people with that name because of how it originated. But there are a number of trademarks out there for Firemark this and Firemark that, and nobody's ever asked me to sign a piece of paper.
Well, and I think that's it. They've got to show the applicants have to show some association that is not connected to Donald Trump or that Trump brand as to why they would be selecting that mark. On the tanning one, it was the argument that it was showing a false connection and association with the Trump brand.
So that was the applicant's argument, or that was the
examiner's argument that there was a false connection. So, and would it be even harder, I think, with Biden, because is there a use besides a surname?
Just Biden my time, but
and that somebody's filed that one too.
I'm sure.
So anyway, narrow ruling by the Supreme Court regarding this is not a violation of First Amendment. We can still have name clause restrictions. You've got to have consent to use a living individual's name. And then if it's a famous but dead individual, there's a pretty good chance there's going to be other issues regarding getting your registration.
Yeah.
But it's not going to be the living individual clause.
Well, interesting. Maybe I'll start pursuing some challenges to Firemarks out there. Anyway, we'll see. Well, let's move on to the next one. This is the Success Kid internet meme. I think you probably know the one we're talking about. I think it's a picture of a very little boy, maybe a year or two old, I think, maybe a little older, with a fist pump kind of a gesture and a scowl on his face, I guess is the best way to put it. A baby clenching a fistful of sand with a determined facial expression is what our notes say. The picture of the meme originated in a photograph from Lainey Griner's son, Sam, who was at the time trying to eat some sand. So she registered a copyright in the image in 2012. So that means this kid is nearing adulthood now. Anyway, the copyright owner of the meme, this Griner family, sued former Representative Steve King and his re-election campaign after they used the Success Kid meme in some campaign fundraising ads. As part of the 2020 re-election campaign, King's team posted the meme on its website, Facebook page, Twitter account, and so on, with the Success Kid superimposed in front of the U.S. Capitol, declaring, "Fund our memes." And the post asked viewers to click on the link to throw a few dollars to make sure the memes keep flowing and the lefties stay triggered. The meme merely changes the original background from the beach to the Capitol building, and Griner said that the defendants never sought or received permission to use the Success Kid template. At the lower court, the jury found that neither the congressman nor the committee were liable for the invasion of Sam's privacy, that the congressman had not infringed the copyright, but that the committee had innocently infringed it, awarding $750 in damages. That's the statutory minimum, of course. Both parties sought costs and attorney's fees. The district court denied the attorney's fees, but granted in part and denied in part the motions for costs. So the main issue on appeal is the fair use defense brought by the committee. Overall, the court weighed the fair use factors heavily in plaintiff's favor. On the first factor, the nature of the alleged infringing use, the court found for the plaintiff, saying memes used commercially in advertising or fundraising are subject to stricter copyright standards than those used non-commercially, which is often fair use, and considered the committee's use purely commercial without any further purpose that would make it transformative enough to sustain a fair use defense. The second factor favored the plaintiff, and the defendant conceded that. The third factor concerning the amount taken also favors plaintiff because it took the heart of the work, the image of the boy. And the fourth factor concerning the market effect, the court weighed in favor of either party because the court doesn't think there's enough evidence that the use by King's committee revitalized the market for licensing the meme. That's an interesting argument that King's committee made, revitalizing the market. Anyway, aside from the fair use issues, the outcome on appeal is that the plaintiff was only awarded $750. The court did not award attorney's fees to either side. So,
is that a win or a loss?
Well, it's a win on principle, certainly. Yeah. But this is what we have to counsel our clients about all the time, isn't it?
And I'm just like, wow. I mean, they took the heart of the picture.
Mm-hmm.
How is that not? I guess they just couldn't show damages.
It's interesting.
And then I think the question also, or something that was raised in one of the blog posts, was that I guess if it was a true innocent infringement, the damages would have been even less. Yeah. Maybe is it 200 or 250? But maybe they pled that wrong, so they could have gotten out for less damages.
Well, I don't know. Damages is an interesting question. I mean, she registered the copyright, so why?
Right, and so
that is the statutory damages.
Well, I guess that's the minimum statutory damages versus $30,000.
Yeah. So, part of it is the jury came back and said, we don't think it was all that serious. So the lowest amount of statutory damages, but I guess they didn't try to prove how much fundraising was accomplished with that ad during that time.
Right. What did he make versus what did she lose? I don't know. That's a tough one.
Yeah.
It's hard to choke down to say that could happen with somebody's copyrighted.
Yeah, and it's interesting because you first off, you might think right away, well, political speech, right, and so that would weigh in favor of a fair use finding. But the court said no, this is commercial because it's a fundraising. So I guess, but money is speech, right? So yeah. It's interesting, and we'll see if this kind of thing comes up again. I think it's cautionary tale for political campaigns, and it may play into the use of music in political campaigns that we've seen every election cycle. So,
well, now it's not even every election cycle. It's just, it's all the time. It's all the time. It used to be a highlight every 4 years we got to talk about. Yeah. Now it's nonstop.
It's wild that we've been doing this long enough to sense a change in that trend away from every 4 years too.
Yeah, or at least every 2 years if we were doing not off of presidential cycle, but yeah, every 4 years. Yeah,
well, our next story is a trademark office situation involving Bacardi rum. Bacardi and Company Limited versus the USPTO. The Havana Club trademark registration for rum is what's in question here. The original trademark applicant at the USPTO, a Cuban corporation, Jose Arechabla S.A., was seized by the Cuban government in 1960, and because of that, the corporation didn't review its trademark registration in 1974. Cuba government-backed organization, Cuba Export, filed a new trademark application in the U.S. for Havana Club for rum. In 1995, Arechabala sold its interest in the Havana Club trademark to Bacardi, and Bacardi petitioned to cancel Cuba Export's trademark registration. The USPTO denied the petition, and yet Cuba Export's trademark could have potentially expired in 2006, in July of 2006, according to the Lanham Act regulations. However, a trade embargo was implemented on Cuba at the time, so they couldn't properly pay the renewal fee required from the PTO. So once the Department of Treasury's Office of Foreign Assets Control denied Cuba Export's petition for an exception from the embargo, their entire renewal failed. And in January 2016, the Office of Foreign Assets Control approved Cuba Export's petition, reversing the earlier decision. And the Commissioner for Trademarks accepted its 2006 renewal application and renewed the Havana Club trademark registration 10 years later. Bacardi then sues the PTO under the APA, Administrative Procedures Act, I believe it is, right? That's 5 U.S.C. Section 702 and 706 sub 2, and sought an order setting aside the director's renewal decision declaring the Havana Club trademark registration expired back in 2006 and instructing the PTO to remove the expired registration from the registry. District Court dismissed for lack of subject matter jurisdiction under the APA, since the Lanham Act typically precludes judicial review. So the issue in the case here on appeal is, can a third party seek judicial review of a PTO decision granting a renewal application? And in a unanimous 3-judge appellate ruling, the court ruled that the federal law doesn't preclude lawsuits over the USPTO's trademark renewal decisions, even though it may do so with court complaints over the office's registration decisions. Interesting. So nothing
is interesting.
Nothing in the Lanham Act expressly precludes judicial review of PTO's trademark registration renewal decisions. Section 21 specifically authorizes parties dissatisfied with certain decisions by the director or the TTAB to appeal to the U.S. Court of Appeals for the Federal Circuit or institute a civil action in federal district court. So to comply with this, the case will be reversed and remanded for further proceedings consistent with this judgment. So,
yeah, because I'm also wondering, depending on, I didn't go look at the Cuba Exports, what was that the name of it? Their application registration, depending on how they filed it, I mean, they may, did they actually, is it still in use? Because they may not even control it anymore. I think that's probably part of what's going to be argued.
Sort of an abandonment argument.
I bet.
Yeah.
Yeah. I've never really thought about this whole, you can't renew your mark because you can't get your money out of Cuba scenario, but there it is.
Well, it's interesting. The trademark for aspirin back in the 1920s, 30s, I think it was maybe even the teens, was not abandoned. It became genericized.
Generic.
Because the Bayer company in Germany wasn't really able to do anything beyond the borders of the German.
Oh, I did not realize that's why.
Yeah, it happened during one of the two wars where they weren't able to stop the Allied folks from using it as a generic term.
As a genericizing it.
So here we have a trade embargo.
Yeah, that's stopping that
kind of impact. It's kind of Anyway, so defamation in the I'll sort of categorize it as the true crime genre of television and media. Is interesting to me because true crime podcasting is such a big genre within that field that these kinds of cases are starting to brew in the podcast world as well. But the case that we're talking about is Netflix, Netflix and Fairstein. Netflix and the filmmaker Ava DuVernay settled this lawsuit brought by a former New York City prosecutor, Linda Fairstein, who had alleged that she was defamed by the show When They See Us, which was a dramatized 4-episode miniseries about the Central Park 5 case. The court depicted Fairstein as the face of the unrelenting and unfair criminal justice system that wrongfully convicted 5 young black and brown boys of the attack on Trisha Melly in the Central Park in New York. The trial, which was closely followed by industry professionals, due to its potential bearing on artistic liberties that we see in these kinds of storytellings, would have been able to, would have set the boundaries for things. And the trial was scheduled to begin this month after a judge in the district court last year determined that the jury could find 5 of the scenes defamatory and so sided with Fairstein on the summary judgment motion. So here we were set for trial. She was looking for $8 million in damages and a court order ordering that the allegedly defamatory scenes be removed from the film and that a disclaimer appear at the beginning of every episode. So the parties now have settled. And one sentence of that disclaimer that was in the end credits will now be moved to the beginning of the credits. It says that it's a dramatization of some of the events. And that's it. She did not receive a monetary payout, but Netflix has agreed to donate $1 million to a charity called the Innocence Project. And that organization devotes its energy to exonerating wrongfully convicted individuals. So that's a positive cause.
Right.
So this is one of a number of defamation lawsuits surrounding this category, this genre of show that dramatizes real life events. This month, a Scottish woman filed suit against Netflix in court here in California for defamation over a show called Baby Reindeer, in which
I started watching. I was like, I'm just totally not getting into this show. I didn't realize it was, quote, based on potentially true facts, but okay.
You didn't realize, so there wasn't a big banner at the beginning, or you didn't notice a big banner?
Maybe I did. Maybe I noticed it, and I've since forgotten it.
Yeah. So that was that was the argument, is that she said, you say it's based on true events, but then you've fictionalized some of the facts that in the TV show she's portrayed. This woman, who is not used by her real name, not portrayed in her real name, is portrayed as having been arrested and convicted of crimes relating to stalking and things, when in fact she never was. And it turns out that the internet sleuth community identified who the real person is.
Oh, really? Because my recollection was, now that we're talking about it, was, I was more enthralled with the, and maybe this was how it was kind of pitched, was that the bartender who's trying to make it as a comedian, more of, it's his story and less about the stalker. And I will tell you, the actress whose name I cannot remember, who portrayed this woman, I just love her. But And so, that was kind of why I started watching it. But then I was like,
Yeah.
But yeah, I could see how if you can figure out who that person is, she was not portrayed in a great light.
And that raises an interesting question. Is that the standard in defamation? I mean, we know if it's of or concerning a specific person, but if the public has to go to sort of extreme lengths to figure out who we're talking about, is that defamation, or is the changing of names and things sufficient to protect the identity? And, look, you can never conceal things entirely. So that's the big question in my mind. And I think we'll see that as that case moves forward, if it continues forward. And then Buster Murdaugh, the son of the convicted family murderer Murdaugh, whose first name I can't remember off the top of my head, is suing Netflix and Warner Brothers and others in South Carolina over a defamation from a 2023 series about the Murdaugh murders, where he is portrayed as being somehow associated with the murder of one of his high school classmates or something. So, and again, had never been charged or convicted with that crime, but the portrayal seems to strongly suggest that he may be the one responsible for that.
Now I have watched that one. The portrayal does.
Yeah.
I mean, yeah. But who knows? Right. And so I think, how do you feel like, because we're talking audiovisual media versus podcasting, which is audio only, do you think there's a distinction in the analysis on these defamation claims? Does it matter?
I don't think so. Even if it was in print, it would still be defamatory.
Sure.
I think in the Murdaugh case, my understanding is, even though they I don't know if they call him out by name, but the actor who portrays this in the dramatization is a redheaded boy of the same build as Buster Murdaugh, who is redheaded. So that may go further in establishing we're talking about this specific person. But
I mean, I do wonder, because depending on how well the story is told when it's an audio only medium, what does it conjure up? Versus the visual impact of seeing it without maybe even something being said.
Yeah, that's true. I think that one of the distinctions between the true crime podcasting genre and the narrative fiction style television show is that the true crime tends to be presented in a more documentary, here are the facts kind of style, rather than just storytelling to make it a compelling, entertaining story. So that may actually weigh more heavily against the podcasting community, where we're saying, hey, here's what happened, A, then B, then C. Very factual in its tone, and you don't have these dramatizations happening. And that's not always the case, but it typically the true crime. So something interesting.
And I'll just put a plug in here that Gordon does a great true crime podcasting CLE.
Oh,
so
I forgot about that.
That's right. So if you ever would like to have him come and speak on true crime podcasting, I'm really sure he'd be down for that.
Relating to podcasting, this is my jam. So cool.
But the true crime one is always fun.
Yeah.
So.
Yeah. How long ago was it that we had the episode where we had the drone piloting licensing thing?
Oh my gosh. And I felt like we were on the forefront, the edge of drone and licensing, and how you could use it and how you could not use drones, all the way back to 2016. May of 2016. Is that 8 years ago?
Episode 74.
Episode 74. And we have come a long way, baby, in the world.
95 episodes since then, yeah.
95 episodes. And in drone usage, I mean, as I watch things, I'm always like, gosh, that would have been really hard to get that shot 20 years ago. I'm sure you, being even more creative and in that field, really feel that way. But we're talking about Hollywood drone pilots. And again, we talked about drone law back in episode 74 with Enrico Schaefer, our legal drone expert. We were so delighted to have him on to tell us about all the ins and outs of getting a pilot's license to operate a drone. And a lot has happened since then. But on June 13th of 2024, this year, major film and TV companies agreed to cover drone camera crews under IATSE union agreements following an arbitration that favored the IATSE Local 600. For years, many drone operators did not know if they receive fair working conditions, at least those comparable to their other unionized coworkers, what they were afforded while they worked in Hollywood. The decision gives protections and fair wages to drone crews, crews who have arguably made 21st century media cutting edge and exhilarating. Watch anything, and again, you'll kind of go, how'd they do that? Local 600 members and drone crews have rejoiced because now they're going to get their pensions, their benefits. And if a unionized production refuses to cover these employees, drone camera crews can contact the production's business manager to request the coverage that they are required. The union's business manager to request that coverage. So again, this goes to if it is a union production and if it's a union production in California. Is that right?
I think it's.
Or is this going to be all IATSE? That's the correct pronunciation of that acronym, right?
Yeah, it's the International Alliance of Theatrical Stage Employees, I think is the meaning of IATSE. And 600 is I think that's the same local that covers camera operators sort of across the board. I could be wrong about that. But so, no, I think it's nationwide, maybe. Well, it's international. The union, if you're making a film, that's the local you use for that trade. So local isn't the right term, but that's the way they do it. So,
well, it's the same thing as the Federation AFM, the musicians. It's the local,
but I don't think it's regionally local. I think it's local to the particular trade in question in the film industry. So.
No, I think it would be. I think it maybe this covers more, but I think local 600 is Hollywood, and then there's going to be a different local for Dallas.
Oh yeah, that's okay. True. I just I don't know if every region has a local that covers the particulars of that trade. So it is broken up by trades within the union as well. So. Anyway, it is interesting, and I think it's a win for the folks that have been flying camera drones for quite a while now. And I think a lot of them were already members of the union and sort of objecting to the fact that the producers would go outside the union to find someone who's non-union to pay them less and those kinds of things. So now it's definitely.
And I still think there's a lot of other regulations that need to be reviewed. I think it's probably a whole lot easier to get a drone license these days, but still there's lots of restrictions on where you can fly drones and what you need to get permission to fly a drone. And the amateur drone pilot may not be thinking about
I didn't go look, but I wonder, are the helicopter pilots who fly for the production studios, are they members of the union? They're probably they're probably Teamsters or something like that because it's a transportation.
That's transportation.
But if they're also running camera as part of the, who knows?
Or is it the person sitting in the helicopter running? Yeah, I don't know. So, interesting.
I think this is just catching up with the technology and the way the industry operates these days, and a good move, I think. So
I think so too.
Yeah.
So we've got a little music to talk about.
Yeah, take it away. Let's talk about it.
Well, so this is a really interesting conversation to have. I think this case raises a lot of questions. How are we going to go with pronouncing this first name? Ithier?
Yes.
Ithier? Ithier versus Ithier versus Aponte Cruz. And it deals with sound exchange royalties, which are digital public performance royalties collected by Sound Exchange for public performance on the internet, from webcasting, cable radio, all of those different things, which is a fairly new right in the U.S. in the last 20 years that artists and record labels would get paid for. So, but in 1962, way further back, Raphael Ithier founded the musical group El Gran Combo and established EGC Corp to manage his rights in the band. The group typically over the years consists of 14 members, singers, instrumentalists, a director, and Ithier controlled who were the members of the band. He also hired backup vocalists for recordings these folks may not have been official band members. And the plaintiff or the defendant in this case, Carlos Aponte Cruz, was a member and lead vocalist of the band, the El Gran Combo, from 73 to 2014, contributing his voice to over 200 recordings. So historically, sound exchange royalties, we're just talking about that one specific stream of revenue from El Gran Compo's sound recordings, were remitted by Sound Exchange directly to the corporation. The corporation did not distribute those royalties to the band members. I guess it all went to what I'm going to assume is the single member and owner of that, which was Ithier. But in 2017, after leaving the band, Aponte Cruz requested his share for the royalties from Sound Exchange, claiming he was a featured artist. He filed evidently a claim with Sound Exchange, and Sound Exchange, like all royalty collection services, do what they do best. They just freeze the money because they're not going to work out what the dispute is between the parties.
Hey, let's
you guys figure it out. So Sound Exchange is designed, and actually the way, this is Tamera's memory and legislative history, but it was designed specifically so that record labels could not cut out the artist getting paid directly. That was the hope. So 50% of the money goes to the copyright claimant of the underlying sound recording, which typically would be the record label. 45% goes to the featured artist, and 5% gets divvied up, or actually it's a little bit different. 2.5% to non-featured artists and vocalists. There's been a little bit of change where producers and engineers get a piece of that pie, but 45% goes to the featured artist on the recording. And so you submit your paperwork, you tell Sound Exchange how to divvy up the pie, and then that's how they pay out the money. But it sounds like that the label in this case, the entity EGC Corp, said we're getting our 50% as the copyright claimant, and we're getting the rest of the percent as also being the featured artist on that, on each of these recordings, which actually goes completely against what the whole process that was set up when the act went into place was that the featured artist would get paid directly and not be cut out by the record label.
That's if you think of the company as the label. If you think of the company as the band, the artist itself.
That's true. Yeah. It's different. And so you could file as a featured artist as a band, and they would have to submit documentation claiming this is the organization of the band and we're getting paid. But the court went on to say that, he was a non-featured artist is only entitled to collect non-featured artist royalties. And Aponte Cruz counterclaimed, asserting his rights to royalties as a feature performer in all of these recordings. He moved for summary judgment, requesting the court to rule that the members of El Gran Combo who performed on recordings should receive royalties as featured artists. So that could mean for each recording, there could be a different group of folks being a featured artist, which is not unusual. But the district court, following a magistrate judge report recommendation, and this is in Puerto Rico, granted summary judgment in favor of Ithier and his corporation, ruling that El Gran Combo as a corporate entity is the featured artist entitled to royalties, and he, as the sole member, gets it all. He gets all the pie. In the appellate court, it all turns around 17 USC 114G, which was introduced as part of this Digital Performance Right and Sound Recording Act, which established Sound Exchange to collect the royalties. And it established this exclusive right for digital audio transmissions and a public performance. And again, we talked about this 50% and 45% going to the recording artist, 50% to the copyright owner, and then the rest is divvied out to non-featured musicians, producers, and so on. Mm-hmm. So the question is El Gran Compo a distinct entity, or does that refer to the individual members of the band, which would include Aponte Cruz as the lead vocalist? And initially, there's a need to determine if Aponte Cruz raised his current arguments in the lower court. So did he actually present this and for the appellate court to rule? Of course, Ithier is claiming that he forfeited the arguments by not presenting them initially, claiming he only argued for individual rights to royalties and not as a band member. Mm-hmm. However, the court found that he consistently argued that the featured artists are the band members, not just Ithier. Okay. And the court went on and addressed the merits of the case. Ithier and the corporation arguing the district court correctly held, of course, that El Gran Compo as a corporate entity is the featured artist entitled to all the royalties. But the court said this interpretation conflicts with longstanding practices where Sound Exchange, representing various music industry organizations, distributes 45% of statutory royalties to the solo artist or members of a group of artists featured on a recording, and not to the owners of the band, regardless of whether the cover of an album contains a recording. The cover of the album mentions only the band or the individual band members' names. Mm-hmm. And the court disagreed with Ithier and the corporation's statutory interpretation. They looked at dictionary definitions of featured as being displayed, advertised, or presented as a special attraction. And he goes on to argue because the album covers features only the wording El Gran Compo and no individual bands, that there is no individuals who should be receiving the royalties, and that the reasoning applies that the corporate entity is entitled to royalties. But the court said this is not a natural interpretation. A natural interpretation is that individual band members performing on the recordings are featured, while session musicians and backup vocalists are considered non-featured. Additionally, the statutory text suggests that recording artist or artist featured refers to natural persons who perform, not artificial entities like corporations. I think the court concluded that statutory interpretation and language and legislative history do not support Ethier's arguments or the corporation's interpretation. And Aponte Cruz and other band members are the recording artists that are featured on the sound recordings and are entitled to statutory royalties, contrary to the district court. And I agree. The whole point was this went to the performing featured artist. Now, if the performing featured artist wants their money to go into a loan out company or be held in an entity, they can file a letter of direction for Sound Exchange to pay whoever the artist wants them to pay. The goal was not for the quote record label, which I think which is what I'm equating EGC to in claiming this artist's share, to get all of it and cut out the featured performers. So I think they went a long way to get there, but I think it was the right decision.
I suspect on the facts in this particular case, it is. What troubles me is that there are lots of situations, especially with a larger musical group, like a jazz big band, or Tower of Power in the horn section.
Sure.
Right? Is each of those horn players a featured player because they play on every recording, or are they members of the group? I mean, if the second trombone player isn't available for a particular gig, they bring in another trombone player to play the part. They're a hired.
That's right.
That's more like a session player, I guess. But is that really the distinction? You play on most of them, so you're the featured player, or?
Well, so it's each sound recording is going to have a different claim allocation filed with Sound Exchange.
Okay.
So do I believe that all of these members of these big bands, or we went and saw Lyle Lovett and his large band? And do I believe that the large band members are featured performers? No, I think Lyle Lovett's the featured performer.
Yeah.
and the others are not.
I think I mean, we know that a lot of sessions now still to this day don't use written contracts with all the session players and the sidemen that come in and so on. I think that's part of we have a definitional issue around what's a session player, what's a sideman, what's a featured performer. The the law tries to do that, and here that's what the court seems to have been grappling with.
Right. And if he was if Aponte Cruz was the lead singer on 200 recordings, what he in effect has done has helped all the other artists and performers on these recordings potentially get a piece of that 45% of the pie.
So when you have a band, I'm just trying to think of an example. Chicago, is Peter Cetera a member of the LLC or a shareholder in the corporation that is the band? And therefore, is it separate payment? The corporation isn't the record label; it's the band, right? So it's a lot to wrestle with.
It is, and how I typically see it is you list the featured artist at Sound Exchange.
Yeah.
Then if that featured artist wants to provide a letter of direction to say, pay XYZ Corp my share, they can. But it's not XYZ Corp who's the featured artist.
Yeah.
And so amongst the band members, they need to determine who the actual featured artist is.
So a lot of paperwork.
It is a lot of paperwork. It is a lot of paperwork because I work for a client right now, and the individual is the featured artist.
Yeah.
The check goes to somewhere else.
Mm-hmm.
I mean, that's just how we have to set it up.
And when that individual artist, that individual natural person who does the performing, has a company set up for tax and liability, like a loan out company or a personal services corporation, now what?
The same thing. We still have to put in the featured artist is Bob Smith.
And that's where the
John Doe. And then we do a letter of direction, and John Doe would like his money to go to John Doe LLC.
Okay. All right. Interesting. Sounds. Yeah. I think what the takeaway is when you're bringing in session players on a recording, make sure you do have a written contract that specifies which of these categories they fall into: featured, non-featured, session player.
That's right. And so this is sorry, I don't have the link here in the show notes or in my head. But if you are typically a session player, a non-featured session musician, there was a big settlement in the last 2 years.
Yeah.
Regarding those royalties, go to the AFM, SAG-AFTRA.
I was going to say the
settlement fund
here too. Yeah.
Yeah. So the money for the non-featured part of that 4.5% actually gets paid and is processed out through the AFM. You may have some money.
Okay.
As part of a settlement on some of these not being paid. So just a little extra tip there on the union side.
That points us to a somewhat elegant transition to our next story, which is part of our AI corner, because we can't do an episode these days without talking about AI. SAG-AFTRA, the union that represents actors and on-screen performers, has created a waiver for AI voice acting. They've come out with a new AI waiver that would allow SAG-AFTRA members to contribute their voices to interactive AI systems like the Scarlett Johansson voice for the AI assistant that we heard about a couple of months ago, or if another actor wanted to do voices for Siri or Alexa or something like that. It would also cover commercials, and basically it requires that the actors be paid for certain reuses and things like that. So the union has come up with an approach. I think it's still pending ratification by members of the union, but I haven't heard noise that it's a problem. It may be a little bit like closing the barn doors after the horses have already run out.
Got it.
So there's that. And then, of course, we had the EU passing its AI law, regulations regarding the use of artificial intelligence, chatbots and things like that, regulates it according to the risk with regulations that cover generative AI like ChatGPT, requiring a summary of the material that was used to train the AI, which will probably lead to more litigation when that material is copyrighted and unlicensed material, and labeling of images as being AI-generated deepfake and things like that. I think this is a great start, and I think the U.S. will be following suit. And in fact, the FTC has posted its informal guidelines in a blog post on the FTC.gov website. They've blogged about how businesses that use AI should make sure that they're not misleading consumers and stealing private information. So there are already, AI influencers out there, some use of the AI-generated models that are sort of standing in the position of the influencer human, and creation. Okay. Yeah, so.
Because I was like going, people. What the heck is an AI influencer? Yeah. But it's a fake influencer.
Yeah, well, I don't remember.
Okay.
I mean, I remember years ago, I think around the time Forrest Gump came out, we were talking about synthespians and the ability to basically clone a real person into a performance that they never, what we now call a deep fake. Now we're doing it with people who never really existed, these completely AI generated things, and they're becoming influencers in their own rights. And I could see companies wanting to have their spokesmodel be an AI generated thing.
Oh, sure.
You design your, hey, the tidy bowl, the guy in the little boat, right? Or the Pillsbury Doughboy.
Right. But those are animations versus it being a design to look like a human being.
Yeah. Well, okay, so
we
let's
think
take
is a
Mr.
real
Clean.
person.
I could see Mr. Clean creating an AI-generated version of the Mr. Clean character that looks and behaves very much like a human, where you can't distinguish this is not a real actor.
Yeah.
As Mr. Clean.
As Mr.
I don't
Clean.
have an earring, but for those watching the video, I just crossed my arms in front of me and put on a big grin.
Are you auditioning?
I should do that as a Halloween costume some year.
You should do that as a Halloween costume. Okay, so I broke out into a little bit of a sweat when I saw the bar exam listed in our rundown, only because all these years later, I still get a little bit of anxiety come July of every year.
I will credit John Janicek, our managing editor, for bringing this case to my attention, and he is a much more recent bar grad than bar pass attorney than I am, but he is experiencing some Schadenfreude pointed in the direction of the California Conference of Bar Examiners, whatever it is. So if you're studying for the bar exam in California in the next few years, that exam is going to be changing. And sort of nationwide, the bar exams are going to be changing. There was a budget crunch for the California bar, certain admissions funds facing insolvency in a couple of years if things don't change and we aren't able to raise dues and whatnot. But the California bar has been seeking to replace the multi-state bar exam, the multiple choice part of the exam, rather than continuing to pay fees to the National Conference Board of Examiners, which is the organization that makes and publishes that part of the test, that multi-state bar. So they also want to open up the ability to enable remote testing so applicants don't have to go to a convention center and all those things to take the exam. So the MBE itself, the multi-state exam, is going to be replaced with a next-gen bar exam that will start to be administered just 2 years from now in 2026. So in their effort to replace that MBE or whatever the new next-gen thing is, the California Bar reached out to Kaplan Test Prep Company to generate a new version of a multi-state or multiple choice exam, and using maybe Kaplan's test centers as proctors for the exam and so on, starting in February of 2025. But the National Conference Board of Examiners, the test organization, raised a concern, sending a letter to Kaplan reminding them that their use of material from the existing MBE is under license from the committee or conference, and that license restricts reproduction or distribution of the test materials without express permission. So Kaplan then withdrew its proposal, said to the state of California, not going to do it. We're not, too hot of a potato for us. So the state of California is now, the bar of California is now sort of casting about for another approach to this. Apparently, the conference, the committee of bar examiners, is reaching out to try to clarify these concerns and so on. But interestingly, the California Bar had at some point made some comments mentioning that any vendor that wanted to be part of this replacing the multi-state exam would obviously have to use the MBE in order to do its job. You'd go back to the old questions and
That's right.
recreate. So that raises interesting questions. Now, the interesting one is that if the state bar of California is a state actor, then it may be exempt from copyright infringement suits, just like the state of North Carolina in the Blackbeard's Revenge situation. But Kaplan is a private for-profit entity, so they, I think, wisely took a hands-off approach on this one.
Yeah. Well, and then there's this whole question of, is each individual question original enough to be protected by copyright, or is it the way in which they are organized together? And again, again, a little heart palpitations and sweaty palms of some of these fact patterns could be original enough to be protected by copyright.
I don't remember the MBE that closely, but it didn't seem like they were very extensive fact patterns for these multiple choice questions. But
yeah, maybe not.
As someone who has taught college and had to come up with test questions, it is hard to write a test question that does a good job of asking of eliciting the knowledge and leaves out the stuff that could take someone in the wrong direction. It's more than just true false all the time. And
yes,
so
there's an art to drafting a good multiple choice question.
And test material and answer material for tests are specifically enumerated as copyrightable material in the Copyright Act. So clearly the creators of the act were thinking about or the lobbyists that were coaching the creators of the act were thinking about these kinds of things at the time the act was made. So not litigation, not a dispute yet, but ultimately we may see more on this front. And it wouldn't surprise me if other states kind of go in this direction too. Everybody's going to be watching California on this one.
Yeah. Well, and good luck to everyone who's studying for the bar right now, because you are getting close to the end for that July. The last week of July. I don't know if I've ever told this story on here, but I took it at the big Dallas Market Hall area and Convention Center area. And the same week we're taking the bar exam and didn't stay at home, stayed at a hotel down there. Yep. It's the Mary Kay Cosmetics Convention. So and I love Mary Kay. I'll be honest with you. I love their brand and their products, but the hotels were full of angst-ridden bar takers, law students, and overly excited Mary Kay representatives. So I always remember when the Mary Kay convention is too.
Well, when I sat for the bar exam, I also went to the hotel near the LA Airport Conference Center, and I stayed at the hotel. And the California exam is 3 days, and the middle day is this multi-state exam. And I woke up that morning with a migraine. And I thought, oh, this is bad. And I took some meds and I caffeined myself up, and I went and I passed on the first try, but
there you go. I had a friend, same experience, different outcome. So we did a half a day on Tuesday, which was Texas state stuff. Mm-hmm. Then a full day on Wednesday, which was the multi-state, and then a full day on Thursday, which was Texas. So the half day was procedure.
Oh, sure.
The full day was multi-state, then a full day of Texas-specific essays.
Oh boy.
And
it makes me
sorry, I hope
uncomfortable
no law.
even
I know,
recalling this.
I know. I hope no law students are listening. So, you know how at least on the essay portion, they prepare you that they always ask the same questions. It's always going to be, you know, here's your family law, here's your real estate, here's your real property. These are always the types of questions, the types of fact patterns. So, you know, you can study and prepare and know how your process is going to flow. They asked a question in the state specific law portion that had never been asked in the history of a Texas bar exam.
Wow.
I'm like going, wow, I don't remember this fact pattern ever being discussed.
Well,
but anyway, they still call us lawyer, don't they?
I was going to say, you and I have been practicing for a very long time, both of us. There may be folks that are newer in practice, and even just this conversation, I'm sure, is triggering some post-traumatic stress.
We're triggering. We are triggering. We are sorry about that,
well,
folks.
Anyway, good luck to all those who are taking it this summer, and that's going to bring us to the end of this episode of Entertainment Law Update. As always, we are grateful to you and say a big thank you to our loyal listeners for spending your time with us. And big thank you as well to JD Supra, our sponsor, the leading platform in professional services content marketing that helps lawyers turn their expertise into networking, opportunity, media, visibility, and new business. Find out more about JD Supra by visiting resources.jdsupra.com. And that's going to be it. If you have feedback for us, and we hope that you do, you can leave it for us by emailing us at entertainmentlawupdate@gmail.com, or head on over to the website at entertainmentlawupdate.com and use the little voice widget on the website there, a little red tab that'll let you just record your voice and send us that message. You can send us a tweet or an X message or whatever it is by reaching out to our handle there at entlawupdate. And Tamera, fill in the blanks on how we can find you.
Yeah, well, always a fun episode again, and fun to do this, Gordon. Yeah. So you can find me online, tbennettlaw.com, tbennettlaw.com, or createprotect.com, and on most social media at Tamera Bennett.
And I'm Gordon Firemark in Los Angeles. The website is firemark.com. The email address, gfiremark@firemark.com. And gfiremark is the handle on most of the social media websites out there. So let's also say a big thank you and shout out to our crack team of volunteer contributors. We've got our managing editor, John Janicek. We've got Charles Thorne, Alexis Allen, Violet Zhang, and Tasha Spear and Dawson Holder, all of whom were instrumental in creating this episode. So listen, if you're interested in joining us as part of the team that puts this thing together, reach out to us, entertainmentlawupdate@gmail.com. And that's going to wrap up this episode of Entertainment Law Update. Thanks again for listening.